letting agents responsibility towards you, things like evictions, safety checks, licensing, where you can get help and how you can complain. And today we're going to hear from two fantastic women, two great experts in this area, Karen O'Sullivan from the Housing Advice Centre at Advice for Renters, and Molly Delaney, who's the casework and policy officer at Safer Renting. Can I remind people that as we are recording and live on YouTube, if people want to stay anonymous, please do use the Q&A chat function for that anonymity. And then without further ado, I'm going to hand over to our first speaker, Karen, who has a set of slides to share with us, and we'll give her a minute to share her screen. Over to you, Karen.
Absolutely. Hello, everybody. Let me get my slides up. So share screen, here we are. And can everybody see them? Right. So I'm focusing on shorthold tenancies in the private rented sector because there are different rules for other types of tenancies. And these are the shorthold tenancy is the most common one that you're likely to have. So, and my brief is requirements to let out a property and what you can do when those requirements are not met. So we'll start with the fact that your landlord must give you a house rent guide before you move in, or even if the tenancy is renewed. And this is a guide that tells you what your tenancy rights are. So yeah, so you're aware of what the landlord can and cannot do. If your landlord doesn't give you this guide, then it means he can't give you a Section 21 notice, which is the way to evict you through the no fault process. So yeah, I don't know if you know that the landlords at the moment can evict people even if they're perfect tenants with the Section 21 procedure. So but not if you haven't been given the correct how to rent guide. There was something else I was going to say here that I've forgotten now. Yeah, so I'll move on to the next slide. I've only got 10 minutes, right? So I have to whiz through these. Another thing your landlord must give you, why isn't it going there? Must give you before you move in is your energy performance certificate. So this is a certificate which rates the efficiency, the energy efficiency of your property, and it bands it from A to G. So if your property is below band E, it can't be let out. Again, the landlord can't use the no fault procedure if they haven't given you this. And if you haven't been given, well, if there might actually be an energy performance certificate in place for the property, and it might be that you haven't been given it. It still means that the landlord can't evict you using the no fault procedure. But I suppose if it is there, then you wouldn't complain to the council, and the landlord wouldn't get fined if he's got one. And I've got on sort of at the end of the slides a link you can go to find out if there's an energy performance certificate over your property and what the banding is. And then this isn't particularly useful for a short-hold tenants because the security at the moment is quite precarious because you can be evicted for no fault of your own. But if you wanted to carry out your own works, either by getting a grant from somewhere or even funding it yourself, then you could get your landlord's permission. And so moving on to the next slide. A gas safety record. Your landlord must provide you with a gas safety record. So they have to have their property inspected for gas safety, and you've got to, and they've got to give you the gas safety certificate before you move in, and then renew it on a yearly basis. And when it's renewed, they must give it to you within the 28 days of the inspection. Again, they can't use the no fault possession if they haven't given you this. And you can ask for enforcement either through the health and safety exec or the local council, and the landlord can be fined and even imprisoned for this one if it's a bad one. And so another requirement is to do with tenancy deposit protection and the information that the landlord must give you. So first of all, your landlord has to give you, if you pay a deposit, the deposit must be placed in a government approved scheme. So there are 3 in England, and you can, to find out if they have protected it, your deposit, you can go to the website of each of the deposit schemes, find out if it's there or not. Regardless of whether they protected it or not, they have to give you lots of information to do with your deposit. So the name of the scheme and sort of what to do if you disagree with, at the end of the tenancy, say that your landlord wants to withhold some or all of your deposit. You can, we won't get into all the details, but another thing they've got to do when they give you this information is they've got to sign a certificate to say that, to the best of their knowledge, the information is correct. And they've also got to give you an opportunity to sign that, to say that to the best of your knowledge, the information is correct. So the deposit amount, etc. If they haven't protected your deposit or given you the prescribed information, then again, they can't use the Section 21 no fault procedure to evict you. And what they would have to do for them to be allowed to use that procedure is to return your deposit, or it's too late. They can't then protect it and use it. If they haven't protected it within the 30 days, they still can't use the Section 21 procedure unless they return the deposit. And in terms of the prescribed information, they could give you that late and then issue you with a Section 21 procedure, with a Section 21 notice. And if your tenancy deposit hasn't been protected, or you haven't been given the information in relation to the tenancy deposit, then you can bring a compensation claim in the county court against your landlord. And you could get awarded compensation up to 3 times the value of your deposit, and also the return of your deposit. And so next is property licensing. So not all properties have to be licensed. Certainly large houses in multiple occupation have to be licensed. So they tend to be houses with tenants, with at least 5 tenants who are from different households and who share facilities like the kitchen and bathroom. Some councils, and you've got to check with your council, will require smaller houses in multiple occupation to be licensed. And so they're properties which have got 3 or 4 tenants from different households who share kitchen and bathroom. And also some councils require all tenanted properties in certain areas to be licensed. So you've got to again check with your council if they run a selective licensing scheme. And the licenses can be granted for up to 5 years, but no more than that. And again, check the license over your property. Also, I don't know, many councils will have a search facility on their websites to see if your property is licensed. For example, Brent has one, and it will tell me if that particular property is licensed, but it won't necessarily it doesn't tell you what kind of license it has. So to do that, you might have to phone your council's private sector, private rented services, or whatever they call it in your council, and ask them to provide you with a copy of the license. If your property isn't licensed, the landlord can't use, again, the no fault eviction procedure. And also you can apply for a rent repayment order in the first tier tribunal and recover rent of up to 12 months, but you must apply within 12 months of the offence. And I've said there, you must have paid rent. It seems obvious, but what I'm referring to is if you're receiving housing benefit or universal credits that covers your rent, then it would be up to the council to make an application for a rent repayment order. And if the landlord hasn't licensed the property, again, you can report it to the council. They can take enforcement action and the landlord can be fined. If the landlord has put in an application to license the property, then they can, as long as that application's gone in, they can use the Section 21 no fault possession process. And then other requirements, the electrical safety report one is relatively new. It came in for new tenancies from June last year and now covers all tenancies. So your landlord must arrange an inspection for electrical safety, the electrical safety of your property. They must provide you with smoke and carbon monoxide alarms. They have to comply with the fire safety regulations. And if they don't, then again, the council can take enforcement action and fine the landlord. I'll add that with fire safety, you can also report them to your local fire services. So in London, it would be the London Fire Brigade, and they too can take enforcement action and fine the landlord. And moving on to badly behaved letting agents. So how to deal with them? I would say first thing is tell the landlord to see if he's aware of it, if he or she might be on your side. You must use the letting agent's complaints procedure first. And then if you don't get a satisfactory response in a reasonable amount of time, then you can complain to their redress scheme. Reasonable amount of time is usually 8 weeks to give the letting agent, a chance to address your issue. And yeah, actually, some letting agents won't be members of a redress scheme. Well, that's not allowed. So, but having said that, if they're not, who are you going to complain to? So you can complain to trading standards, and they can also and you can also report them to trading standards for not being a member of a redress scheme, and they can be fined for that. And then some letting agencies are also members of voluntary accreditation schemes, such as Property Mark or Safe Agent, and you can complain to them if they are. And other remedies, you've got the small claims court or the county court. Yeah, that's a tough one, because legal aid, if you do qualify for legal aid is very limited in the matters, in the housing matters that it will cover. Doesn't cover everything. Small claims court is usually cost effective, and if you make a claim, there's an application fee, but if you win your case, you get that refunded. You wouldn't get refunded costs of solicitors normally in the small claims court. But they can also, apart from awarding compensation, they can make orders for specific performance. If you're to try and make your landlord observe the terms agreed. And then you've got consumer protection law, and the right to unwind it's not often spoken about. It's normally it's something you can use within right at the beginning of a tenancy. So if your landlord or letting agent has used misleading actions or aggressive practices to get you to sign a tenancy agreement, or it can even cover stuff where you've sort of unfair practices. You've agreed to terms or stuff in the property and it's not there. You can exercise your right to unwind, which is basically means terminating your tenancy agreement and walking away from it without any obligations. If you do that within 30 days of the start of the tenancy agreement, then you get a full refund of anything you've paid. If you do that after the 30 days, but within 90 days of the start of the tenancy agreement, then again, you are able to get out of the tenancy agreement and get a partial refund, or maybe no refund, but at least you can release yourself from the obligations of the tenancy agreement. The way to go about that would be to write to your landlord and say that you're asserting your right to unwind rights, and obviously they'd have to agree at least to a refund, and if they don't, then you've got to go to the county court for a declaration that your tenancy has been unwound, and any remedy, any refunds or compensation. After the 90 days, for misleading actions or aggressive practices, you can still try and claim a discount or compensation. Yeah, and that is not time limited, at least. And other stuff, just to remind you, your tenancy deposit can't exceed 5 weeks rent. So if your landlord asks you for more than that, then you shouldn't pay it. You should be aware that mostly letting agents and landlords can't charge you for random tenancy fees. There are specific things they can charge you for, like if you lose your keys, and the cost of replacing them, if you want to end your tenancy early. But again, the level has to be reasonable and reflect what it's actually costing them. Also, this is relatively new. No DSS, so refusing tenants on benefits is not allowed. It's considered unlawful discrimination. And you can, again, if your letting agent is doing that, you can complain to their redress scheme, or you could even go to court for compensation for that. And of course, generation rent has already covered this in a webinar on Wednesday. Your landlord's repair obligations, your property's got to be in good repair. It's got to be fit for human habitation before, from the start of the tenancy and throughout the tenancy. And finally, on a note, it's important to try to maintain a good relationship with your landlord, and communication and good faith go a long way. So there are rogue landlords. I'm not defending the landlords, but sometimes they can be sort of inconsiderate. And if you write to them and point out your problems, they may get on board, and you can resolve the problem without going through the hassle and stress of courts or complaints. So yeah, that's all from me. And my last, oh yes, useful resources. That's our Advice for Renters website. Shelter has got a wealth of information. I think it's on Molly's slides as well. Really practical information, such as templates for complaint letters, how to go about claiming compensation for tenancy deposit breaches. So really useful. And also the Citizens Advice website has got practical information on how to bring a small claim and things like that. And that's the website to find out if your property's got an energy performance certificate, and you can put in your postcode and access that. My last slide, I'll leave you to read in your own time. If Alicia shares the slides, that's what Advice for Renters do. And do approach us if you've got legal issues with your tenancy, welfare benefits, debt management, budgeting, that kind of thing.
Right.
Thank you.
No, thank you, Karen. That's excellent. I know people have learned a lot. I certainly did. And thank you for putting up at the end about what Advice for Renters do. I mean, Advice for Renters and Safer Renting, who we have here today, are both excellent organisations, and I encourage you to get in contact with them. We're going to take there's quite a few questions that have come in. We're going to take the questions at the end. However, there are a couple of questions, Karen, that are specific to your presentation. So from Katie asks, if the tenancy is renewed every year, should I get a guide produced and presented to me every year? And is the landlord required to check the smoke and carbon monoxide alarms as she can't reach them to check them? So those are two that are directly for you, I think, Karen.
The first one, so if a new guide is out, then the landlord doesn't have to provide it during your ongoing tenancy. But if you renew the tenancy, then yes, they've got to provide you with the updated version if one has come out. If it hasn't come out, then no, they don't have to give you a new one. If your fixed term ends, then you get a periodic tenancy, and your tenancy keeps continues from, say you pay the rent monthly, then your tenancy rolls from month to month. Now, if you've got a statutory periodic tenancy, then technically each month you get a new tenancy. So as soon as the new how to rent guide comes out, the landlord must provide it. If your tenancy is contractual periodic, which means that your tenancy agreement states that at the end of the fixed term, it will turn into a rolling tenancy, then it isn't a new tenancy. So if a new guide comes out, so if a new guide comes out, the landlord doesn't have to provide it. The latest how to rent guide, how to rent booklet came out in December. So you can check if yours is the December one. And what was the other question? I've already forgotten.
Sorry, it was about smoke detectors and carbon monoxide detectors. So Katie can't reach hers, but is it the landlord's responsibility to check them?
I believe it's the tenant's responsibilities, for example, to change batteries, and I don't know if they. I'll find out. I think that it's the tenant's responsibility, certainly to change the batteries and things like that. It's the tenant's responsibilities. If it's inaccessible, where is it? Is it could you not get a ladder to access it? I mean, is it a question that it's locked in a cupboard where only the landlord can access it? Or, well, it wouldn't be, because it wouldn't detect very much.
Okay.
But
they're on the ceiling and she's got a disability.
So probably that would be a reasonable adjustment under disability discrimination law, under the Equality Act, I would expect. But let me, maybe I should double check that.
Okay. Right, well, Karen, you can see the chat and you can see that Katie is replying there, so you can have a look. Yeah, okay, great. What we'll do in the meantime, and obviously I've got all the questions that are coming through the Q&A as well, and questions that were submitted in advance by participants. So we'll come to those at the end, and we'll now move to Molly from Safer Renting. Welcome, Molly.
Thank you, and thanks so much, Karen. That was a brilliant presentation. I think it leads very nicely into mine as well. So let me just share my presentation. And here we go. Brilliant. Assuming everybody can see that. Right, cool. So yes, as Elisa mentioned, I'm Molly. I'm from an organization called Safer Renting, and I'll be obviously talking about your rights as a renter in the private rented sector, and focusing particularly around your rights when it comes to a landlord seeking to evict you or to regain possession of the property, and what your rights are in that situation. So quickly, who we are at Safer Renting. So we provide a tenancy relations service to 11 local authorities in London, and we help renters living in the private rented sector who are experiencing harassment from the landlord, illegal eviction and homelessness. So we tend to deal with those rogue landlords that Karen mentioned predominantly, but we also campaign on improving the law and government policy around the issue of illegal eviction. And if you're kind of interested in more on that and what we do, we published a report at the end of 2020 called Journeys in the Shadow Private Rented Sector, which sort of focuses on the kinds of rental arrangements that we deal with. In terms of knowing your rights as a renter, the most important place to start is knowing what kind of tenancy type that you have. So as Karen mentioned, the most common private rented kind of tenancy status you would have is probably assured short-hold tenant. And the basis of an assured short-hold tenancy, or an AST, is a case called Street versus Mountford from 1986, which sort of laid out the hallmarks of a tenancy, which is basically that you pay rent for a fixed term and have exclusive possession of whatever you're renting. So if you rent a whole house, you have exclusive possession of that house, whereas if you are in a HMO and you rent a room, you have exclusive possession of that room. In terms of evictions, if you're an AST tenant, you are required to be served with a Section 21, which is the no fault grounds, or Section 8, which has multiple different grounds for different reasons, like rent arrears, antisocial behaviour, all those sorts of things, required to be served with an eviction notice in order for the landlord to start possession proceedings. Another tenancy type you might have, or another rental type you might have, is a lodger. So that's where you have a live-in landlord, and it's the landlord's sole or principal home. And when the occupier, so when you moved in, the landlord already lived there, and you share facilities with your landlord, which basically means you don't have exclusive possession. So no possession order is required to make you leave. So you be given a sort of basic notice to quit, but then you have to leave. Basically, the landlord doesn't need to go through possession proceedings. You could be a contractual licensee, which again Karen mentioned. Usually that is the case when you can't identify exactly what part of the premises you have exclusive possession of. That can sometimes happen if people like swap rooms at various points, but the contractual element is that you pay rent for a fixed term. And the kind of final one to touch on is a common law tenant, which is similar to a lodger, but you don't share facilities with the landlord, but the difference is you are entitled to a possession order in order for the landlord to get you to leave. So those are sort of like the legal basis of your rights when a landlord is seeking possession. So then it's worth talking about in turn what the definition of illegal eviction is. So this is the Protection from Eviction Act 1977, Section 1, kind of pulled it out because Section 1, Part 2 and 3 sort of lay out harassment and illegal eviction in the law. So an illegal eviction is if any person unlawfully deprives you, the renter, of any part of the premises or attempts to do so, that they will be guilty of the offence of illegal eviction. And similarly, with harassment, if the person does acts to interfere with the peace and comfort of you as the resident in order to force you to give up kind of possession of the property, that's harassment, and kind of in the civil courts potentially also illegal eviction as well, from a civil perspective. And that can, as it mentions there, including withholding services, so turning off the gas, electricity, things like that. That's sort of obviously harassment. So what does that mean? Essentially what it means is any attempt to deprive you of any part of the premises by means other than what is owed to you as your legal rights on the basis of your tenancy type, that is an illegal eviction, and it's a criminal offence, and it's not allowed, it's bad, it's kind of a no-brainer, but that is the basis for the legislation. Now I say this includes the toilet because to kind of illustrate the point, there's a case, Regina versus Burke from 1971, where the courts found that because a landlord had deprived this tenant use of the toilet, they locked the toilet and they weren't able to use it, they were actually essentially illegally evicted from the toilet. But that shows that it is really any use of the premises that's denied to you counts as an illegal eviction. So it's worth saying though, again, Karen mentioned the fact that landlords can currently evict you with a Section 21 for no fault, and that is probably what happens most frequently, is that you would be served a Section 21 if you're a short-hold tenant. But just because you've been served a Section 21 notice doesn't necessarily mean you're being legally evicted. Karen touched on a lot of this stuff, but there are many things that can invalidate a Section 21 notice, or things that a landlord must do before serving a Section 21 notice, as Karen laid out. So I won't go through them again because it's, as you can see, very similar. But what it is worth noting is that because of the COVID-19 regulations and legislation introduced by the government, there have been changes recently to the notice period that a landlord is required to give you when serving a Section 21. So if you were served a Section 21 between 29th of August 2020 to the 31st of May 2021, the landlord needed to provide you with 6 months notice. So that's from the time that you are given the Section 21 to the time that the landlord can begin possession proceedings, so going to court to get back possession, that there needs to be a gap of 6 months. But if you've been served a Section 21 on or after the 1st of June, so just recently, it's dropped down to 4 months notice. Again, I won't go too much into possession proceedings because I believe there was another session done over the course of this series, specifically on possession proceedings, which is a whole another topic unto itself. So yeah, hopefully you'll be able to find that from this series and learn a bit more about the later stage of possession proceedings. So these presentations are always a really good opportunity to do a little bit of like myth busting around your rights. So rapid fire. You do not need a tenancy agreement to be in a short-hold tenant. You know, Street versus Mountford, that legal case established that your tenancy status is based on the actual circumstances, not on kind of whatever piece of paper you've been given, whatever agreement you've been given. So if you pay rent for a fixed term and have exclusive possession, you will be an AST regardless of what your agreement says. Just because your written agreement says you're a lodger doesn't necessarily mean you're a lodger. Again, if you meet the sort of hallmarks of a tenancy, it means you are likely to be an assured short-hold tenant, not a lodger. We see a lot of sham agreements, people being told they're in like short-term holiday lets, things like that. But actually, when you look at the circumstances, they are actually tenants, not lodgers or licensees. Another one, similar to what Karen mentioned, just because your fixed term has ended doesn't mean you need to leave or you're no longer a tenant. As she mentioned, you can become a periodic tenant. So the sort of terms of your agreement just sort of like continue to roll on until either party decides to sort of end the tenancy. So you don't need to leave just because your fixed term has ended. Tenancy is a form of ownership. Again, this is a really important thing to kind of wrap your head around as a renter, that actually legally speaking, you probably have a lot more rights than you think. Sort of the concept of having a lease is sort of set up in law as a form of ownership. You know, again, the concept of exclusive possession, you have exclusive rights to the property, or, you know, part of a property that you're renting. Obviously, as Karen mentioned, you need to work with your landlord if possible, and it's about having a good relationship, but you actually do have a lot more power in having a form of ownership than you might think as a tenant. You are sometimes allowed to exclude your landlord from the property, and you can change the locks in certain circumstances. So if you have exclusive possession of you know, whatever premises you're renting, you can actually, you're within your rights to change the locks if you feel in an emergency situation that you have to, like if you're being threatened with illegal eviction or you're being harassed. But it's really important to note that you could only change the locks to the premises that you have exclusive possession of. So if you only rent a room in a house and you share, you know, facilities with other people in that flat, for example, you could only change the lock to your room, whereas if you had exclusive possession of the whole house, you could, in theory, change the lock to the property. But it is a kind of slight gray area in law, so it's in an extreme circumstance, probably you'd be looking at that. But again, it's a illustration of how you might have more rights than you think as a renter. And finally, kind of again related to illegal eviction, despite what the police often say, illegal eviction is not a civil matter, it is a crime. Often, annoyingly, the police, if we're dealing with an illegal eviction, we call the police, they hear that it's a landlord and tenant dispute and say, oh, that's civil matter, we can't get involved in that, we're not gonna get involved with that, which is wrong. As I showed with the Protection from Eviction Act, illegal eviction is a crime, and yeah, we often try and help tenants to explain to the police, explain the basis of the law, explain their tenancy type to try and get around that. But yeah, worth stating. So briefly, if you are in a situation where you feel like your landlord is trying to unfairly or illegally evict you, I think it's, you know, again, it's worth explaining your rights to your landlord. You do, you know, sometimes get landlords who just are a bit ignorant of the law, not fully aware of the different tenancy types, things like that. So it's worth explaining your tenancy status to the landlord as you understand it based on the law, explain that you need the correct kind of notice as a result of that, and again, the correct notice period, depending on the circumstances. In a sort of worse situation where that doesn't work, your local authority may have a tenancy relations service. So these are the local authorities where Safer Renting works, but there are other local authorities who sort of have their own internal tenancy relations services as well that you could get in touch with if you were experiencing harassment or illegal eviction or felt like you were being unfairly evicted. And it's also worth saying that there are different kind of areas in the council that deal with different types of issues kind of relating to private rented housing. So for example, if you're experiencing disrepair or health and safety issues, environmental health is the team in the council you'd want to approach about that. Obviously, I mentioned tenancy relations service if you're experiencing sort of unfair eviction. If you are living in a sort of bed in a shed, or you suspect that you're living in a sort of like illegally converted property, it's the planning department is the place to go. And again, Karen mentioned that you may live in a local authority or in an area that has property licensing. And if you think that your property may not be properly licensed, you know, given the number of people living in it or the size of the property, things like that, it's the licensing and enforcement team. Sometimes they're called slightly different names, but broadly speaking, these are the areas in the council that you will want to go to. So that was a very whistle stop tour of tenancy rights in the sort of like broadest terms. But yes, there are some other resources that you can check out if you want to learn more. On our Safer Renting website, we have a bunch of sort of like educational leaflets that you can check out. We've already mentioned the Shelter website, and actually as well, if you are very, very interested in the sort of legal stuff, there is actually a website, which is Shelter Legal, which is used by housing professionals such as myself, but goes into much more depth on the sort of like legal, the legislation and all the different permutations of different rights and obligations and things like that. So if you want to deep dive, Shelter Legal might be of interest. So yeah, brilliant. That's it from me.
Great, lovely. Thank you, Molly and Karen. Now, Molly, I had a question that was submitted, which is about where do I go and what do I do when I think I've been illegally evicted. But actually, I'm going to expand that, because you might have seen, you won't have seen in the chat because you've been presenting, but KH in the chat put, interestingly, about the toilet, their landlord actually removed their toilet for an extended period when they wanted to encourage them to leave, and the council didn't seem that there was a problem. And the other part of this submitted question is, can I go back, or is there any way of getting redress, or is there a statute of limitations if I think I have been legally evicted, which clearly in KH's case you may think that they had?
Yeah, okay, so on the point of the removing the toilet, that definitely sounds like the kind of harassment, you know, withdrawal of necessary services, such as use of the toilet in order to encourage you to leave. That's kind of textbook harassment for sure. It really depends on what kind of sort of like legal redress you would be seeking. A lot of it is, again, not necessarily possible with, it's not necessarily legal aid fundable. It would, yeah, so giving a difficult answer giving a thorough answer is difficult without knowing all the details, but that is one option, sort of like trying to get compensation that way by sort of like suing your landlord. If you were sort of like sort of had sufficient evidence, you could also apply, as Karen mentioned, for a rent repayment order on the sort of like basis of severe harassment as well. Yeah, I think it's tricky when your local authority is not willing to. I mean, it would probably actually be seeking the help from somewhere like Advice for Renters would probably be where I would go actually in order to get that help if it's not coming from the council. In terms of statute of limitations, for a rent repayment order, as Karen mentioned, there is a sort of like 12-month statute of limitations from when the sort of like harassment was carried out. So that I'm just seeing it pop up in the chat, that may be past. Yeah, it may be that may no longer be an option unless it's sort of been like sustained harassment over a long period of time. But yeah, if they cancel out helping you, yeah, generally it's turning to organizations like Shelter, Advice for Renters, and they can kind of, on the basis of the specific legal circumstances that you're in, they can best advise on what you might be able to do.
Can I just add, if it's if the property hasn't been relet to somebody else, you could also get an injunction to be reinstated into the property, as
Right.
well as compensation and rent repayment orders, like Molly mentioned.
Yeah, no, thanks both. And yeah, people are asking in the chat to put the contacts for your organisations in the chat, and they can see. We will send around the slides.
Yeah, it's worth saying just on that point really quickly. Safer renting, we generally get referrals through the local authority. So if you live in one of those 11 local authorities that we work with, the best way to get in touch with us is get in touch with the council, say, I'm having these problems. I know you work with Safer Renting, they provide your tenancy relation service, and then, you know, it will get referred through to us that way. So just a quick note on that point. But we can share contact details as well. Yeah.
Great. So Irina asked, and I'll summarise it, but basically it's about tradespeople entering the accommodation, so for a boiler check or to fix a repair. And obviously they give you, you know, 6 hours. I'm going to be there between 12 and 8. Whose responsibility is it to sit in? You know, is it the landlord's, because, you know, you can't take time off work, or is it the tenant's responsibility to wait in to get tradespeople in and out?
Shall I take it? Yeah. Well, you've got to provide access. So you, first of all, they've got to give you a notice, at least 24 hours notice, or check your tenancy agreement. It's not usual, but it might allow for more notice. And you don't have to be there if you're happy for the tradespeople to come and go. Yeah, you just have to give them access to the property. So presumably the landlord will have his own keys, and if you give permission for them to enter without you being there. But again, you've got to give that permission to enter without you being there.
Okay. Molly, anything to add, or that pretty well covers that?
Yeah, I think
Okay. Okay, now moving to the Q&A. Anonymous asks, I'm about to ask my landlord for a rent reduction, but the landlord is managing the flat, but the letting agent deals with all the paperwork. So they've been asked to respond to a letter of intent to stay, but this seems like they are trying to put me into another 12-month tenancy rather than becoming a rolling contract. Regarding a discussion about rent reduction, should I go to the landlord in the first instance, and is their responsibility to discuss this with me? So is it the landlord or the letting agent that you talked to about a rent reduction?
Who wants to go? Molly, do you want to?
Yeah, sorry.
You probably would have a better idea than me, so you can jump in and I'll add anything.
Well, ultimately the letting agent can't approve a rent reduction without the landlord's consent, because it's the landlord's property. So by going straight to the landlord, I suppose you cut the middle person. It depends, you know, what sort of strategy you want to take, who you think will be more, what way you think would be more convincing. Sort of, maybe you can work on the letting agent who can work on the landlord. Maybe you can work on the landlord. They don't have to give you a rent reduction, of course, but again, yeah, I would say, especially at this current time when, you know, if you were renting the same property now, the rent would be significantly reduced. Maybe it's worth going on the property websites like Rightmove and Zoopla, and getting, you know, together information how for what similar properties in the same area go for, to make up a sort of compelling argument to back your request.
Yeah, the only thing just to add on to that, in terms of them pressuring you to sign another 12-month tenancy agreement, you're under no obligation to sign another tenancy if you don't want to. If it's a, you know, periodic tenancy, it will just continue until one party chooses to end it. Rent level changes can be facilitated through a new tenancy agreement being signed. Normally that's the rent being raised rather than reduced, but I mean it may be a way that the landlord wants to sort of like formalize any sort of rent reduction by, you know, setting it, because then that will be the new terms of your tenancy, right? It would be whatever the rent level is in that new tenancy agreement. But so you are binding yourself into it, but yeah, under no obligation to sign a new tenancy agreement.
Okay. Okay, we've got a question here. Someone was misled when shown a flat, and there were many other issues related to the flat. So they're planning to take the issue to the small claims court. So any guides regarding gathering and presenting evidence to that court? They've got a lot of video and email evidence. Is there any guides online to show how best they should do that? And is the consumer protection law useful to cite in small claims court action? So any advice around winning and being successful at small claims courts? I don't know if that's you, Molly, or Karen.
Yeah, I have not done a huge amount of this. I mean, in terms of citing the legislation, obviously when you're making your argument for why you're, in this case, potentially seeking to unwind, I'm not sure exactly what legal action you're planning to take, but you would always want to cite the legislation, or, you know, and the basis for your legal action, right? So if that is on the basis of the consumer law, then absolutely cite it. Yeah, and I think as well, just in general, when you're preparing a sort of like legal bundle, make sure that everything is very clearly labeled. You want to label all the select exhibits and make sure that you very clearly connect the points in your argument to the exhibits that, you know, the evidence that you're presenting. That's just sort of like general tips. But
yeah, and ask the courts. They do have, especially now we're moving into having to provide electronic bundles and stuff, so they will have those data sharing websites. So if you call the specific court and ask them how they want you to send video evidence, then they'll be able to tell you.
Okay, great. Is it okay for the landlord to insist on scheduling inspections every 3 months? Karen, maybe that's you. Or is that harassment? If that's not okay, I don't know.
Well, I wouldn't say it's harassment, but it does seem that it's something that's going to likely to interfere with your right to quiet enjoyment.
yeah,
Seems a bit extreme. So I mean, sometimes landlords put these clauses in the tenancy agreement, and then they've no intention of. It's just they haven't even read it themselves. But if the landlord is insisting on doing that, then I would say it's a bit excessive. It interferes with your right to quiet enjoyment. And yeah, I wouldn't. So yeah, I mean, I just wouldn't let him in, basically, and let him take you to court if he wants or she wants.
Yeah. I think
Katie's just put in the chat, Karen and Molly, that her letting agent has just brought in a new 3-month inspection policy.
Right. I mean, the thing is with any of these things, like when it comes to what arrangement you might have with a letting agent, or even what it says in your tenancy agreement, those are contracts, right? It's sort of like the basis is contract law, and that actually they can put anything they want technically in a contract, but if that would not override your sort of rights as a tenant, and your sort of like protections against, you know, harassment or, yeah, as Karen mentioned, quiet enjoyment of the property. So, you know, just because it's in your tenancy agreement doesn't necessarily mean that if it infringes on sort of other more fundamental rights that you have, that you necessarily need to play ball with that. There is, as Karen says, a risk that they would kind of take action for like breach of contract, but it's not, they don't override your rights as a tenant, it's worth saying.
Yeah, and you can always challenge unfair contract terms, again, through the county courts. But in this situation, I wouldn't go to court for a declaration to say that this term is unfair or unreasonable. You know, I would perhaps write to them. It's always a lot of stuff doesn't have to be in writing, but put everything in writing with a landlord or a letting agent. No matter how chummy you are, it's a legal relationship. So if you just explain that, say it's interfering with my quiet enjoyment of the property, so I don't think it's reasonable, it seems excessive, so I've decided not to let you in. I think a more reasonable gap between inspections might be 6 months or whatever it is, and then you've explained your situation and the legal basis for it. If they really insist on it, then they can't force you. So again, it would be for them to take a claim against you. And I mean, it's not that I'm I'm inviting your landlord to do so, but you can just react to what the landlord does at this stage. And in fact, I think a claim might be harassment or a threat to take you to court itself could be, for something like that, could be harassment.
Okay, we've got kind of time for a couple more. So I live with a friend whose parents own the flat. They don't have a formal tenancy agreement. What rights do they have if they're asked to move out?
Okay, so this is a funny one. It's worth saying that if you are living in a property where you live with members of the landlord's family, that's not the same as having like a live-in landlord. That's different. It's not the same. So in terms of you living with them as a sort of, you know, living with their daughter doesn't make it a live-in landlord arrangement. It would, yeah, I would need to probably know a bit more of the details, like, do you share a room? Is it essentially a sort of like joint tenancy that you have? How do you pay your rent? There's sort of a lot of different kind of questions that might throw up exactly what your tenancy type would be. I mean, from the sounds of it, you would need at the very least a sort of like notice to quit. So they would need to sort of like give you a, you know, sort of proper notice. If you do have a joint tenancy, it's likely that if you have possession of the whole property, that you would be a shorthold tenant. So then all of those sort of like general rights, like they'd need to serve you with a Section 21 or a Section 8, and then go down possession proceedings if you didn't leave at that point. So I probably need a bit more information to be able to properly advise, but yes, just because you live with their daughter doesn't necessarily mean that you're a lodger or anything like that. So
does the landlord live in the same building? Perhaps
that would be another
area.
If they live in an area that you don't share facilities with, that might make you a common law tenant. It would really depend. This is where my casework triage brain turns on, and I want to start asking all these questions. But those are probably the basics of what your situation is.
Okay, we've got time for one more. Yeah, of course you can, Karen.
I just wanted to that question about the smoke alarms and carbon monoxide alarms.
Yeah, definitely.
It seems, according to the regulations, the landlord has to make sure that they're in good working order on the first day of the tenancy. And that's it basically. But they do have a responsibility they do have a duty to make reasonable adjustments for things like disability. So it would be reasonable for your landlord to check the alarms himself if you are unable to because of a disability. Having said that, I mean, they recommend you check those alarms once a month. And going back to the other question, do you want your landlord coming into your home once a month? That's up to you. But, you know, if you've got reason to believe that there's a problem with your smoke alarms, definitely, or carbon monoxide alarm, then definitely get them in.
Great. Thanks,
under the Equalities Act. Quote the Equality Act 2010.
Great. We've got time for one more question, and while you ask that question, I'm going to ask Tilly, who's the generation rent technical support, if she can get the final slide ready for me. This is a question about someone lives in a terrace house. They're at home because they've got a long-term illness, and work has started next door, and actually the landlord owns the property next door, and they're responsible for doing the work next door. Should the landlord, the conditions, the building, that's made her illness worse, should the landlord have informed her that work was going to go happen because it's affected her quite badly?
It's not really our field. It's tort, it's nuisance, it's not strictly a tenancy question. So I would say, big disclaimer, go and seek legal advice from somebody who actually knows what they're talking about. But if I can give my two bits, and it seems to me that unless it's, you know, you're saying, I think we got this question yesterday, and they weren't.
Yeah.
We were told that the works weren't ongoing outside during antisocial hours. So at that point, are they reasonable? For example, there was a case where the neighbor was doing his works, but it lasted 4 years when it should have lasted 1 year, and a judge found that that was unreasonable, and they awarded compensation to the suffering neighbor. But or another, you know, the builders being able to look inside his loo and he had no privacy, that kind of thing. So unless there's something unreasonable going on, I really feel for this person, because it's just something we've got to put up with. But it can be a bit overwhelming, especially when during coronavirus, everybody's indoors a lot more. We're not out in the out at work while these the building works are ongoing, and it really does your head in. But I can't see that unless they're breaching the council's hours for when they can do works, or are otherwise unreasonable, that anything can be done about it.
Okay. Molly, you concur?
Yeah, well, nothing more to add, but just really quickly, there was a question I tried to type an answer to in the Q&A, but I accidentally said I would answer it live. Just really quickly, if you're a lodger, there's no requirement for a landlord to protect your deposit. So unfortunately, you're kind of hanging out of luck there. But unless you're a tenant, in which case all the deposit protection things apply.
Great. Well, thank you both. And in the last minute, I just wanted to end with this final slide to say thank you all for participating in this webinar. We've reached such a lot of people over this week. There's another webinar tomorrow at 11 if people want to sign up. But that ends the Renters' Rights Awareness Week from Generation Rent. Big thanks to Molly and Karen. Aren't they two great, fantastic women with such a lot of knowledge? And I really know that you'd have got a lot out of this session. Now you've started on this journey with Generation Rent, please continue, sign up and stay involved. Tell us your experience. All of organisations like Advice for Renters and Safer Renting and Generation Rent and Shelter, etc., use case studies to develop policy, to make change, and to put your stories and your experience out to politicians to make sure that renting is changed for the better. So please tell us your experience on Vent Your Rent, and indeed join our renters panel where we look and consult you more deeply on policy. And if you want to help us campaign, become a volunteer by signing up at generationrent.org/volunteer. And we know times have been tough for renters, and I'm sure people watching this webinar can't afford to donate, and that's absolutely fine. But as all of our organisations rely on individual donations and grant funding, if there are anyone watching who wants to support our work, then please do so by donating to Generation Rent. So finally, big thank you to Molly and Karen. You were fantastic presentations. I learned a lot, and I know that people watching will have done too. And thank you all for spending your Saturday morning with us. So thanks very much and goodbye.
Thanks for having us. Bye.
Bye. See you soon.